Get ready. 3, 2, 1, start. It has been argued by the Learned Counsel for Appellant that the prosecution had produced three eyewitnesses before the trial court, out of whom PW6 and PW7 were injured witnesses whose presence at the spot could not be doubted. The third eyewitness, PW5, was an independent witness having no reason to falsely implicate respondent number 1 in a case of this nature. He has also argued that the case in hand is a classic case of non-reading of the record by the High Court because the statement made by one of the injured eyewitnesses had not even been discussed by the High Court in the impugned judgment passed by it, whereas the merits of the statement made by PW5 had not even been adverted to by the High Court. He has further argued that the High Court had also misread some crucial parts of the record of the case, which misreading had clouded its vision and had distorted its perception of the facts of the case, vitiating the impugned judgment passed by it. The learned counsel has also contended that the present case was a case of a broad daylight occurrence taking place at a thickly populated area of Lahore. An FIR had been lodged in respect of the occurrence with sufficient promptitude. The eyewitnesses produced by the prosecution had consistently pointed their accusing fingers towards respondent number 1 as the sole perpetrator of the alleged offences. The medical evidence had provided full support to the ocular account. The background of good relations between the assailant and the victims turning sour was admitted by both the parties. The trial court as well as the appellate court had concurred in their conclusion regarding guilt of respondent number 1 having been proved to the hilt, and the High Court has not justified in acquitting the said respondent. It has been maintained by the learned counsel that the impugned acquittal of respondent number 1 by the High Court, based primarily upon serious misreading and non-reading of the relevant record, has occasioned grave miscarriage of justice, clamoring for interference in the matter by this court. The learned Additional Prosecutor General, Punjab, appearing for the state appellant, has adopted and supported the contentions of the learned counsel for appellant and has also prepared for setting aside of the impugned judgment passed by the High Court and restoration of the judgment passed by the learned Additional Sessions Judge, Lahore. Full stop. The end.